Thank you, Margaret. I want to describe the developments that have taken place in Britain over the last 10 years concerning the creation of specialised environmental judicial bodies. Now, some of them, I think, will resonate with what is going on in Ireland, though there are some distinct differences, and notably the position of courts under the Irish Constitution. Now, the story in Britain is by no means over, but in essence, we now have three key developments. First, a specialised planning court set up in 2014 as part of the High Court and dealing with judicial reviews concerning planning matters and some environmental judicial reviews. Secondly, a specialised environmental tribunal set up in 2010 handling regulatory appeals and a wide range of environmental regulations. And then finally, as part of the post-Brexit arrangement, legislation is going through Parliament establishing a new independent body, the Office for Environmental Protection. Now, its powers will include the enforcement of environmental legal duties against government and other public bodies by judicial review. But there is an argument going on exactly which judicial body should be involved if action gets that far. Now, I've personally been involved in all these developments, and it's been something of a roller coaster ride, and one that reveals many different and sometimes conflicting visions of what is needed and what is practical. So I hope that some of what I say today will touch some chords in your own developments. The environment is largely a devolved matter in our constitutional arrangements, and most of what I describe relates to England only, but there are similar developments taking place in other parts of the UK. Now, I will mention tribunals quite frequently, and I should describe briefly the distinct role that tribunals play in our judicial system, which, as I understand it, is not replicated in Ireland. The use of specialised tribunals dealing with disputes between citizens and the state on matters such as social security and insurance began in the early part of the 20th century, and then many more were created by different laws after the war. But in 2007, there was a major reform of tribunals, in essence creating a far more unified and flexible system. And this reform turned out to be important in the context of environmental law. There is now a single first-tier tribunal divided into various chambers and individual tribunals and dealing with appeals from a whole range of bodies such as the Information Commissioner, the Office of Fair Trading, local education authorities, tax authorities, and the like. The system is extremely flexible in that new primary legislation is no longer needed to establish a new tribunal, and specialised tribunals within the first tier can be set up by administrative reorganisation as and when needed. Appeals on the point of law go to the upper tribunal, which is a superior court of record and has the status of the High Court. And indeed, it is also given power to hear judicial reviews rather than the High Court in classes of cases assigned to it by government order. This hasn't yet happened in the environmental field, but it does hear judicial reviews in most immigration and asylum cases. And from the upper tribunal, appeals go to the Court of Appeal and then the Supreme Court. Since the 2007 reforms, tribunals are now fully part of the courts and tribunal service under the Ministry of Justice. And there's clearly a fine line between tribunals and courts. But in essence, tribunals tend to have a specialised jurisdiction. Tribunal judges are appointed through the Judicial Appointments Commission, but will often sit with expert lay members. Procedural rules are more flexible, and at first tier level, litigants in person are accommodated, and proceedings can be less formal than in a normal court. Even in the upper tribunal, procedures are equally flexible. I've only appeared once before the upper tribunal in a case involving a point of law about environmental administrative sanctions. And it was a very different atmosphere from the High Court. Barristers simply wore suits and they made their representation sitting down. The judge, also in a suit, slightly higher, but intervened far more often than is the case in the High Court. In many ways, it felt like a high-class legal seminar. And personally, for this sort of case, I found it very attractive. Now, arguments in Britain about the need for some form of specialised environmental court or tribunal go back almost 30 years. Lord Woolf, then the Lord Chief Justice, gave an important public lecture in 1992 under the eye-catching title, "Are the Judiciary environmentally myopic. His starting point was that real-life environmental problems, such as a major pollution incident, often give rise to many distinct legal issues, from regulatory disputes, criminal liability, civil disputes, and public law. And his vision was a one-stop environmental court or tribunal involving judges and expert members, which could cut across all these legal boundaries and resolve the issues involved in a far more effective and economical manner than existing arrangements. Now, it was a radical vision and one a little too much for government to stomach. But instead, government commissioned a major review of the potential for an environmental court or tribunal, conducted by Malcolm Grant at Cambridge University. And this included examining specialist environmental courts established in other countries such as Sweden, Australia, and New Zealand. It was a massive study, but perhaps deliberately the terms of reference were to identify possible models rather than coming up with a single recommendation. Professor Grant outlined 6 possible models, ranging from the most modest, the development of our planning inspectorate, hearing planning appeals into a tribunal, and right up to creating a new environmental division of the High Court, hearing environmental judicial reviews and civil claims. Environmental NGOs naturally clamoured for a new division of the High Court, but there was no political appetite for change at the time, and the debate simply petered out. Now, I'm somewhat of a pragmatist, and I couldn't see a new High Court division happening in the near future. But I did spot a potential problem area in our system of environmental regulation. Appeals against refusal of planning permission go to our planning inspectorate. Most specialised environmental regulations also contain appeal rights against the refusal of a licence, imposition of an environmental notice, and the like. But the appeals bodies were completely incoherent. Some went to the planning inspectorate, some to the county court, some to the High Court, some to the minister, and so on. And it was really a historical accident rather than logic. I did a report for the government in 2003, arguing the case for consolidating all these environmental appeals to a specialised environmental tribunal. It was far more modest than the idea of a new High Court division, but it did fill a particular need. And although at the time new legislation would be needed to set up such a tribunal, it did seem politically possible. Industry, lawyers, the judiciary, and government all supported the idea. But I failed to ring round the environmental NGO community, who thought this all too modest and didn't meet their aspirations for environmental justice. Once again, everything stalled, and I rather assumed that was the end of the story for many years. But a few years later, I was commissioned by our Cabinet Office to review the general system of regulatory sanctions. This went well beyond environmental law, covered some 60 national regulators and local government, from food law, consumer law, building law, and so on. Now, the ultimate legal sanction then for nearly all regulatory offences was a criminal prosecution with strict liability offences. Basically, I felt the criminal law was doing far too much work, and that regulators should have access to a range of administrative sanctions as an alternative to criminal prosecutions. Criminal prosecutions would still play a role for the truly egregious, but for the company who breached regulations, say through oversight, an unexpected breakdown of equipment, or carelessness at the most, non-criminal sanctions should be made available. There would have to be an appeal system, and I recommended that rather than go through the ordinary courts, we should now use the new flexible tribunal system that was being created at the time. Gratifyingly, the government accepted all the recommendations, and it turned out that the first regulators to acquire the new powers were our Environment Agency and Natural England, which they did so in 2010. The Courts and Tribunal Service, anticipating a large number of appeals against environmental sanctions, immediately established within the first tribunal a specialised environmental tribunal. Since then, there has been a general policy of having any regulatory appeals in new environmental legislation handled by this environmental tribunal. In addition to appeals against administrative sanctions, the tribunal now handles around 40 separate appeal provisions, from marine licensing, nitrate zone designations, emissions trading, to climate change agreements. At present, there is one salaried judge, about 6 judges with environmental tickets, although more are being recruited, and there are about 6 non-legal experts, mainly hydrologists dealing with nitrate zone appeals. Now, these regulatory appeals are all appeals de novo, rather than a review of the legality of the decision reached by the original body. But as with planning appeals in this country, only the person who has been refused the original license or wishes to challenge conditions or appeal against the sanction and so on has the right of such appeal. There are no third-party rights of appeal. And third parties, such as NGOs wishing to challenge decisions, must do so by way of judicial review, subject to standing requirements, which are pretty generous in the environmental field. And of course, any challenged must be focused on the legality rather than the substance of the decision in question. Judicial reviews are normally heard in the administrative court, a specialised division within the High Court. Now, once the UK, along with the rest of the EU, had ratified the Aarhus Convention, the whole question of whether these procedures were compatible with the requirement that court procedures in Aarhus cases should not be prohibitively expensive became very much a live issue. Judicial review is an expensive process and always accompanied by the risk that the loser may have to pay the other side's legal costs. For a number of years, the government ducked the issue, and the courts valiantly tried themselves to use protective cost procedures within the limit of their discretion. But eventually, in 2013, the government introduced new rules, which in Aarhus judicial reviews cap adverse cost orders to £5,000 for individuals and £10,000 for organisations. Since then, the rules have been amended, giving judges rather more discretion to override these figures in particular cases, and the uncertainty that this is potentially created for litigants still raises doubts whether the procedures are truly compliant with Aarhus. But in the same year, 2013, the government became very concerned at the delays taking place in judicial reviews in the administrative court in planning cases, and the chilling effect this had on development proposals and economic recovery. They consulted on the possibility of transferring all planning and environmental judicial reviews to the upper tribunal, feeling that its more flexible procedural rules, greater emphasis on case management, would be a preferable judicial reform than the High Court. The government's sole concern was delay. Now, I supported the proposal because I felt the upper tribunal, with its use of both legal and expert members and its flexible procedures, were far more aligned with Aarhus than the High Court. The procedural rules of the upper tribunal start with provisions that could in many ways be said to reflect wholeheartedly the aspirations of Aarhus. And I quote, "The overriding objective of these rules is to enable the upper tribunal to deal with cases fairly and justly." And then the rules go on to say that dealing with cases fairly and justly include dealing with the case in ways which are proportionate to the importance of the case, the complexity of the issues, the anticipated cost and the resources of the party. B, avoiding unnecessary formality, seeking flexibility in the proceedings. C, ensuring so far as practicable that the parties are able to participate fully in the proceedings. D, using any special expertise of the upper tribunal effectively. And E, avoiding delay so far as compatible with proper consideration of the issues. Now, it has to be said that not all High Court judges favoured the tribunal system, and there was something of a fight back, and the judiciary proposed the establishment of a specialised planning court within the administrative court. With more specialised judges and more forceful case management, cases could be decided more speedily. The government accepted these proposals and the planning court was set up in 2014. And it now handles judicial reviews and related appeals in planning matters and EU environmental legislation, though presumably this will be amended post-Brexit. The planning court can fast-track cases which are determined to be significant cases as defined in practice directions, essentially those involving significant economic impact, raising important issues of law, or generating significant public interest. And from talking to those who are involved in such cases, it's pretty clear that in terms of speed in reaching decisions, the planning court has been effective, and in that sense has met the government's original concern. Now, the final and third development is the proposed Office for Environmental Protection. This will be a new independent body, essentially filling the gap post-Brexit when the European Commission will no longer exercise a supervisory function over the UK concerning its compliance with EU environmental law. As with the Commission, the Office for Environmental Protection will operate a public complaint system, allowing anybody to submit complaints where they feel a public authority is failing to comply with its environmental law duties. The OEP will not investigate all complaints, but must develop a strategic enforcement policy, indicating the sorts of cases it will focus on, in much the same way that the European Commission does now. And these are likely to be cases where there appear to be systematic failings, or where, say, there is significant and irrevocable damage to the environment. And the focus is always on the public sector, local authorities, statutory bodies, and government departments. Now, as is well known, in its infringement procedures, the European Commission is able to settle perhaps 90% of its cases without the need to go to the European Court of Justice. The OEP procedures are clearly designed to encourage resolution without having to go to court, if at all possible. As with the European Commission, there is a three-stage process. The OEP makes the decision to launch an investigation, either in response to a public complaint or on its own initiative. And there is a statutory duty on public bodies and government departments to cooperate in its investigations. It may then issue an information notice stating why it believes there is a failure of environmental law public duties. Now, if the matter is not resolved then, the OEP can move to the second formal stage, a decision notice, stating why it believes there is still an unresolved breach of environmental law duties. Now, importantly, at that stage, it can also set out the steps it feels must be taken by the body concerned to remedy the breach. And this is potentially a very important innovation. In traditional judicial review, unless we are talking about the simple quashing of a consent decision, say, courts are often reluctant to get involved in prescribing detailed remedial steps that must be taken. The recent air pollution litigation involving Client Earth and the government was distinctive because unusually the relevant EU legislation on air quality standards actually specified what must be done if there was a breach of air quality standards. Essentially, the government must produce a plan to remedy the situation as soon as possible. So inevitably, the courts got involved in reviewing the complex plans produced. But I'm not aware of other EU or national legislation which contains equivalent provisions. Now, if the matter is still not resolved at this stage, the OEP can then take the issue to court. Now, in its original proposals, the government had provided that this would be by way of ordinary judicial review in the administrative court. Now, I argued in front of parliamentary committees that while one hoped court action would be rare, it was frankly rather unimaginative to revert back to ordinary judicial review in the High Court. And it would be preferable if such actions were heard before the upper tribunal. As I've said, the procedures are more flexible, and particularly if the arguments were about detailed remedial steps to be taken, involving economic and scientific judgments, the use of expert members in the upper tribunal could be extremely valuable. Now, gratifyingly, the government accepted the argument, amended the legislation, and provided that OEP enforcement action would be heard by the upper tribunal, but applying the ordinary principles of judicial review. The bill comes back to Parliament this month, but 3 weeks ago, the government proposed amendments, and these now will revert back to having cases heard before the High Court again. Now, they haven't fully explained the rationale for the change, but I think the view of senior government lawyers was that with OEP judicial reviews being heard before the upper tribunal and environmental judicial reviews brought by third parties, such as NGOs, before the High Court, this could lead to inconsistencies in approach. Now, personally, I'm not convinced this is a real danger. The upper tribunal is sufficiently flexible that, in fact, a High Court judge can be transferred to hear a particular case in the upper tribunal. And from my personal experience in judicial reviews, it's often the personality of the particular judge assigned to the case which is far more important than the forum where it's heard. It does seem to me rather a lost opportunity to try something new. But in general terms, I welcome the proposal for the Office for Environmental Protection, and in fact have argued that even if Brexit hadn't happened, it would be a valuable contribution to our system of environmental governance. Environmental NGOs don't cover all areas of environmental law, and the Office for Environmental Protection has other important functions, including a general duty to review the implementation of environmental law. Now, this is something we've never done systematically in our national environmental law in the absence of some scandal. Some years ago, the chair of the European Parliament's Environment Committee memorably said, "We are good midwives, but poor mothers," meaning that governments and legislatures are often good at passing new laws, but rather less so at following them up and nurturing them, as it were. The powers of this new body to review what is actually happening on the ground across the field of environmental law will be innovative and important. So, across the water, as it were, environmental law is in for exciting and potentially unsettling times. Thank you very much.